rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting with the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is State versus Hicks, and we will hear from the appellant.
Good morning, Your Honors. My name is Michael Henry. I am a Special Deputy Attorney General with the North Carolina Department of Justice. I wrote the state's briefing before the court in this matter, and as in Hicks 2 back in April 2023, I'll be arguing on behalf of the state today. I would like to reserve 10 minutes for rebuttal should it become necessary. Just some notable procedural background to orient us. The defendant was convicted in 2019, appealed to the Court of Appeals. The Court of Appeals found that the defendant did act in self-defense, and the trial court erred in instructing on the aggressor doctrine. As a result of that decision, the Court of Appeals didn't address the state's Exhibit 174 and 175, which the defendant had contended was plain error. That was Hicks 1, or what the state refers to as Hicks 1. The state petitioned this court for discretionary review. It was granted, and this court held that the Court of Appeals had erred by treating the defendant's testimony as fact, and there in fact was evidence from which it could conclude, the jury could conclude that she was the aggressor, and so it remanded to the Court of Appeals for consideration of State's Exhibit 174, or her arguments as to 174 and 175. That was Hicks 2. Then the Court of Appeals came out with Hicks 3, which is the opinion that actually underlies the state's current appeal before this court now, which is that the admission of 174, the Court of Appeals found the admission of 174 and 175 under Rule of Evidence 403 was plain error, with Judge Murphy dissenting on prejudice. And the state filed its notice of appeal based upon the dissent. So that brings us to today. Technically, today is all about plain error and has nothing to do with the defensive force issues addressed in Hicks 1 and Hicks 2, although defendant's MAR filed last week seeks to change that and relitigate some of our defensive force analysis. So to that end, my plan today is to open with plain error, addressing each element in our contention, the state's contentions as to why defendant satisfies none of those elements and why the Court of Appeals erred in holding that was the case, and then move on to the defensive force issues raised by defendant's MAR, should that turn out to be warranted. Okay. In that regard, turning to the first element of plain error and the primary or threshold issue that is before this court, in the state's view, which is whether discretionary rulings such as 403 determinations are eligible for plain error review at all. The state responds that they are not. This court and the Court of Appeals has held this on multiple occasions, and it largely appears to be a practical consequence of the review of discretionary rulings and the plain error standard itself. With respect to the latter, this court held in Reber and elsewhere that plain error is for the rare cases where the harshness of the traditional preservation rule requiring an objection vastly outweighs its benefits, and therefore plain error as a principle reflects a compromise that in exchange for forgoing or overlooking the typical preservation requirements, the appellant must meet a heavy burden with respect to either an evidentiary or instructional error, which is that it was a fundamental error that had a probable impact on the verdict in an exceptional case. This case fails to meet any of those criteria, as we'll discuss. But for right now, as to the threshold issue of whether discretionary rulings can be plain error at all, by their nature, review of discretionary rulings is incompatible with this analysis, which is to say that even a preserved discretionary ruling, if this had been preserved, if the defendant had objected with respect to Rule 403, review would be for whether or not the trial court's decision to admit State's Exhibits 174 and 175 was manifestly unsupported by reason or so arbitrary that it cannot have been the result of a reasoned decision. Applying plain error review, which is ostensibly even a more onerous standard than that, or somehow would be a more onerous standard than that, would effectively eliminate the preservation requirement altogether. It's not entirely clear how we would even review what standard would lie below the idea that the ruling itself was manifestly unsupported by reason or so arbitrary that it could not have been the result of a reasoned decision. The practical effect would be that unpreserved complaints about myriad discretionary, evidentiary, or instructional issues would simply become ubiquitously reviewable on the basis of plain error. And that is not the law, nor should it be the law. Plain error is intended to address whether fundamental fairness has been compromised, not whether a discretionary balancing test might have gone another way. Our courts have repeatedly held that. This court in Gillard in 2024, Steen in 2000. Neither the Court of Appeals nor the defendant have identified any case that concludes an unpreserved Rule 403 challenge amounts to a showing of plain error. And in this regard, Hicks 2 appears to stand entirely alone in North Carolina jurisprudence as a published case to the contrary, and that's fairly remarkable. So from a bottom line standpoint, plain error review is reserved for fundamental breakdowns of trial court fairness, errors so serious they destroy confidence in the verdict, and Rule 403 rulings are, by contrast, inherently discretionary. And these two categories are simply not doctrinally compatible.
Sorry to interrupt you, but
please.
I have the sense you've given us the meat of that argument, and what I want to first explore is how we reach that when we're here on an appeal based on the dissent, and the dissent in this case starts out with the sentence, "I agree with the majority that the trial court erred in admitting those exhibits."
Right, yeah, and that's exactly the lines of what was involved in Your Honor's dissent.
But it was a dissent.
But it was a dissent, right, yes, that's right. But, and you argue there that we really can't divide up plain error this way. We ought to sort of view it holistically. And the majority said, no, look, this is only on a prejudice analysis. And that is the same kind of question that Your Honor's question is presenting. I think there's a distinction there that's pretty important. One is the error at issue in River, for example, is a 404B error. That is an error that is actually capable of being subject to plain error review. And so, at least in principle, we can distinguish the idea of whether or not there is prejudice that arises from this error. We can all just agree that error occurred, and we can move on to argue whether or not there is prejudice. In this case, based on Gillard, based on Steen, based on all the other cases that the state has provided in that large footnote in its reply brief, 403 rulings are simply incapable of serving as a plain error ruling. So the Court of Appeals reached a unanimous conclusion that an error that is incapable of being plain error was plain error, and then differed on prejudice. And now we would be in this court, if we hold to that line, we say, no, we're just going to assume that it was error. We're effectively overruling, this court would effectively be overruling its cases that exclude Rule 403 determinations from the plain error analysis, and then conducting an assessment of whether or not prejudice for purposes of plain error has arisen for an purported error that can't possibly be plain error. And that just seems sort of confused.
Yes, but there certainly, even in the 403 context, if a court is under a misapprehension of the law, as it is applying its discretion to include or exclude evidence under 403, that would be, we can still find that a court makes an error, that it's an abuse of discretion if there's a legal error, correct?
If it's preserved, sure. Then we would have a preserved error, and we would review for abuse of discretion, which is whether it's manifestly unsupported by reason and so on.
But I understand your argument that there can never be plain error under 403 flows from this presumption that because it's discretionary and it's an abuse of discretion standard, it can never be plain error. But even under the abuse of discretion standard, if the judge makes a complete error of law, that is an abuse of discretion.
Yes,
So-
and the abuse of discretion standard applies if it is preserved.
But why wouldn't it be plain error? If the court is just completely wrong about the law,
Right.
why wouldn't we still be able to review that under plain error standard? What's the logical inconsistency for us reviewing that under a plain error standard?
Because plain error is a remedy on direct appeal that forgoes the idea that preservation is required. That does not apply to discretionary rulings. I think to really get to the meat or the sort of substantive issue underlying Your Honor's question, and correct me if I'm misunderstanding this, but the real issue is, okay, let's just say that we have a Rule 403 determination that is just outrageous. It's either some kind of misapprehension of the law or some kind of ostensibly discretionary ruling, but it's just outrageous. And defense counsel does nothing, so it's unpreserved. Can't we get at that through plain error somehow? And my response would be no. That is not available on direct appeal. It has not been preserved. If the defendant wants to review or wants some kind of review of that error, that is an MAR issue. That is a ineffective assistance of counsel issue. That is a we need a hearing. Why didn't my lawyer jump up and say something so that we could get an objection that creates a record? And now we have an issue that we can pursue that way and create some kind of independent record. But on plain error analysis, on direct appeal, discretionary rulings like Rule 403 determinations simply aren't available. There might be other aspects of whatever this hypothetical ruling is we're saying that somehow are evidentiary or instructional related, and that could somehow come under plain error, and then we're in that ballpark again. But the plain error remedy on direct appeal would be unavailable.
And you also have at least some question, don't you, about whether or not allowing the evidence to come in, not jumping up and down, not objecting, was part of trial strategy. And that's why an IAC claim, at least arguably, is a better avenue.
Is the better avenue. That's exactly right. And that, in fact, appears to be the case here. I mean, defense counsel, in closing argument, talked about how the jury, quote, needed to see those texts so they could get the context that they provide for the relationship between these two people. That those texts are the key evidence that defense counsel uses to establish how hostile and aggressive and so on Caleb is, which is crucial for defense counsel's defensive force argument. And defense counsel, in fact, made extensive use of these texts in cross-examining law enforcement witnesses. In the 3 days that the jury was exposed to this material, a significant amount of it was defense counsel's uses of them. So, and that's exactly, Your Honor is exactly right. That is the issue where if you were to raise this, if a defendant was to be convicted and say, this was just outrageous, I can't believe my lawyer didn't object, this was unpreserved, I can't have that reviewed on direct appeal through plain error because it's a discretionary ruling, but I think that failure of counsel to object to that was a deficiency of counsel and that I was prejudiced, and I can argue that and prove that. There's a way to resolve that. What we wouldn't do is have an appellate court apply a plain error standard on a record that says absolutely nothing because it's unpreserved. The record makes no findings as to admissibility or any kind of weighing or anything about anybody's strategy. And then we're going to apply a plain error standard on a discretionary balancing test that could have just gone either way. That just strikes me as the wrong tool for the job when it comes to a discretionary test, specifically Rule 403 tests, which this court has specifically articulated relatively recently, are not subject to plain error review. So, and to loop that back to Justice Earle's original question, that idea of how do we review that? How is this issue even before this court? The idea that the Court of Appeals is applying a plain error analysis to an error that, as a matter of law, it cannot apply to, seems to undermine the idea of then, okay, well, now we're going to limit our analysis to just whether or not there's prejudice on an error that can't have been applied to in the first place.
But shouldn't you have filed a petition for discretionary review to ask us to examine that issue?
I did. The petition for discretionary review was denied. Which this court is welcome to do. I mean, it has supervisory authority. The court can do as it wishes. I just think, and to be clear, I do think if this court limits its analysis to prejudice, the state still wins. So that could happen. I think this case fails all elements of plain error analysis. And if this court wants to limit it solely to prejudice, it'll fail on that analysis too. The Court of Appeals should still be reversed. But I just think there's something somehow confused about doing a prejudice analysis on an error that can't possibly be the error for which we're doing the prejudice analysis on. Particularly given that the Court of Appeals now has a published case, apparently the first one in North Carolina, that says this is, a Rule 403 discretionary ruling can be a plain error.
And the Court of Appeals had the benefit of Gillard and certainly Steen at the time they issued this opinion.
Yes, and in fact, they had the benefit of, the state dropped a large footnote, and that originally started as a footnote in my briefing, and then it just became unwieldy, and so it had to go to a footnote, just going through all the cases that say Rule 403 discretionary tests are not subject to plain error analysis. All right, so just stopping right there, I think that is fully warrants reversal, and this court could say nothing else and just lean on that. I do think we can keep going though with the fundamental error issue of plain error in terms of the lack of deference. I mean, even if we assume that plain error review is available for discretionary rulings, that leads immediately to the other issue, which is that the Court of Appeals never acknowledges that this is a discretionary determination. And I think that's important because when you acknowledge, if this had been a preserved case of a Rule 403 dispute, unquestionably, the standard appellate process would have been to acknowledge the standard of review. Again, manifestly unsupported by reason, so arbitrary it could not have been the result of a reasoned decision. The Court of Appeals never makes an assessment of that. That never is part of their analysis. They just conclude it was error, I think under a de novo or an implied de novo standard, suggesting essentially that the Court of Appeals wouldn't have admitted this. So that itself is simply another wrong way to do an analysis. Any plain error analysis, plain error layers on top of the underlying error. Without an error, you can't have plain error. So you have to first properly find the error. And the Court of Appeals simply doesn't do that. So we have not only a case to which plain error is inapplicable, but even if we were going to assess plain error, we don't assess the actual error that would be that underlies the Court of Appeals' ostensible analysis. And then even ignoring that, if we actually do apply that standard, basically providing treating this as if it was a preserved error, and apply that standard, which is say, is the trial court's decision so manifestly unsupported by reason or so arbitrary it cannot have been the result of a reasoned decision, the opinion below simply overstates the gravity of States Exhibits 174 and 175 in terms of anything related to their impropriety. I mean, defendant's trial spanned 22 days, including 13 days of actual trial, 18 states' witnesses, 223 exhibits, 6 defense witnesses, along with 36 exhibits. These exhibits, States 174 of 175, are 2 of those exhibits, and they include the text messages with defendant and Caleb and others, but overwhelmingly Caleb, in the 13 weeks prior to a domestic homicide involving these 2 people. They amount to 221 single-sized, regular-sized pages. They're right here. This is what it looks like. Of these 221 pages, a total of 16 are intimate images. I say intimate in the sense of, but 11 of them being non-explicit, by which I mean like selfie photographs of you in bed with somebody else, but you just see each other's faces, that kind of thing, or kissing or something like that. Non-explicit. 11 of the 16 photographs are that way. 5 of the photographs are explicit. I've marked them right here in yellow. So of this entire collection, these are explicit. Several of these were sent by defendant to Caleb in the days prior to the homicide with threats to send them to his wife, meaning these images directly precipitate and provide the context to the actual shooting underlying this case. The jurors only had copies of these for the 3 days during which there was direct and cross-examination. Now, is this material relevant overall? Just generally speaking, is the correspondence between the victim and the shooter relevant? I don't see any argument that you could say it's not. relevancy is obviously defined under Rule 401, but this court explained in Hill to elaborate on this idea of making any fact of consequence more or less probable, that it does not have to bear directly on the question at issue, which is who shot, when and why did the defendant do the shooting, but pertain to, quote, the circumstances surrounding the parties, and be necessary to be known to, quote, properly understand their conduct or motives, or, quote, weigh the reasonableness of their contentions. I mean, the correspondence between the shooter and the victim in the weeks leading up to a homicide, it strikes me as outrageous to say that's not relevant as a general proposition. So then we come down to the individual items, this text or that photo or whatever. Even to the extent any of these are irrelevant or could be considered irrelevant, text to her son about needing a physical to play school sports or something like that. It's very difficult for me to wrap my head around how the admission of that material could be a fundamental error for purposes of plain error. That is so prejudicial, so lacking in its elements, that justice can't have been done, a miscarriage of justice. I mean, that just strikes me as something that we just can't possibly conclude. So we're left with another independent basis for reversal, which is that regardless of whether it's available, these texts are overwhelmingly relevant and at most include a handful of irrelevant items.
As long as we're talking about alternative bases, can I also ask you about the issue of invited error? Isn't that a cleaner way to say the defense here used these exhibits? Isn't this invited error? Don't full stop, end of story.
Absolutely. I petitioned for discretionary review on that. It was denied. So, yeah, but I agree.
2 for 2.
That's right. So I do want to talk, I've already cut into my rebuttal time, but I do want to at least touch on the issue that is ostensibly directly in front of this court, which is the prejudice probable impact prong. So setting aside fundamental error, this was the split point between the dissent and the majority in the court below. This court's recent decision in Reber, of course, explains what probable impact means for purposes of plain error, which is to say, quote, probably would have returned a different verdict, not a reasonable possibility, not a high plausibility, but not a lack of overwhelming evidence going the other way or something like that, but rather that a different verdict must be significantly more likely than not, almost certain, presumable, or doubtless. The evidence here simply does not approach this standard under any rational view. As an initial matter, defendant has not identified any indication or evidence in the record that any of the hypothetical grounds of prejudice she argues, which is that the jurors might have looked at these, they might have left them open for pages, or might have studied them independently. There's simply no evidence in the record to that effect, which incidentally loops back to my initial point about discretionary rulings being appropriate basis for plain error as opposed to, say, an MAR. There's simply nothing in the record to suggest any of the ills that the defendant has suggested did in fact happen. Moreover, the undisputed evidence here with respect to conviction is really pretty narrow. I mean, the defendant shot Caleb in the back from at least 6 inches away with a gun with which he was well practiced. His key and vape were on the floor near his body, suggesting he'd taken them out of his hands. He was halfway out of the bedroom. The shells that were fired from the gun were found in the bedroom. She had no visible injury. She didn't complain of any pain at the scene. Defendant's home had little to no damage. Her narrative evolved from the time she met officers at the scene until the time she testified at trial, and never explains why it was necessary or why, for some reason, she shot him in the back from a distance, and the jury took less than 2 hours to reach its verdict. So at base, the jury was effectively asked whether they believed a version of defendant's narrative suggesting she shot Caleb in the midst of some kind of chaotic assault, or whether they accepted the forensic evidence that she shot him in the back after he turned and was leaving, and the jury sided with the forensic evidence. To me, that is unsurprising, really borderline inevitable. So it's very difficult for me to see any way in which we have a highly likely, probable impact on the verdict arising from the admission of this evidence. To quote Reber, the question is not whether the challenged evidence made it more likely that the jury would have reached the same result, which is clearly the case here. Instead, the analysis is, without the evidence, whether the jury probably would have reached a different result. I struggle mightily to see how this evidence arrives at that conclusion. That just leaves the exceptional case requirement for plain error, which neither the majority nor the Court of Appeals and defendant don't really even discuss. And I'm not sure I see any reason to think that this is a case that seriously affects the fairness, integrity, or public reputation of judicial proceedings. So with that, I will reserve the remaining portion of my time for rebuttal. Thank you, Your Honors.
Thank you, counsel. Hear from the FLE.
May it please the court, my name is Marilyn Ozer, and I'm here once again representing Wendy Hicks on her appeal of second-degree murder conviction. And I want to help out my colleague here to tell him that he doesn't really need to struggle to figure out why this was prejudicial. A man broke in forcefully into a house after being told twice not to come. A third party heard him shouting, "I'm going to kill you." She then heard noises of an assault in the bedroom. This is clear castle doctrine. So the question is, why did this jury go off the rails? Why did they not find self-defense? The castle doctrine says it's presumed if someone breaks into the house forcefully, the defendant has a right to be afraid, has a right to protect herself and her daughter in this case. And the question of what went on before, in the 13 weeks before that we have texts, totally irrelevant. The question is what happened then. And I need to go back to the plurality decision that this court made because Justice Dietz, joined by Justice Berger, brought out the fact that as part of the aggressor instruction to the jurors in the trial court instructed the jury that an aggressor includes a person who uses towards one's opponent abusive language, which, considering all the circumstances, is calculated and intended to provoke a fight. Now, Justice Dietz and Justice Berger found that that was improper, but it wasn't properly preserved, so they couldn't reach it. But it's crucial to understanding why this was so prejudicial, to understand that this jury that we're asking would they have reached a different verdict had been instructed that they could basically use those texts to find my defendant didn't have a right to defend her home. You can also see this in the plurality opinion, which finds on page 385 NC, page 63, the jury could draw inference from this couple's interactions that Ms. Hicks sought to provoke Mr. Adams and that she was angry when he seemed to indicate that he wanted to end their relationship. So even this court's opinion, the last opinion, uses these texts to find that Ms. Hicks was guilty of murder and didn't have a right to self-defense. So I don't see how anything could be more prejudicial than instructing a jury that they could use these 231 pages in order to find that my client did not have a right to self-defense under the Castle Doctrine. I would also go back to Justice Earle's questions to the state. And I'm a little bit surprised that his whole argument is on 403. When the instruction from this court, the order stated, accordingly, only those issues which are the basis of the dissenting opinion in the Court of Appeals shall be presented to the court in briefs. The dissent in this case did not disagree with the finding that the evidence was irrelevant and prejudicial. What he dissented on was how prejudicial it was. Didn't meet the plain error standard. They didn't go into 403, whether or not that's discretionary. But if this court wishes to overrule its own order and consider that, Rule 403.
But before you get into that, let me ask you a question, because since it does seem the scope of the review here is a central point of dispute, isn't it true that in his dissent, Judge Murphy talked about Reber and arguably may have misstated the rule that came out of Reber?
I believe it's misstated in that Reber says that there has to be more than an even chance that the jury would have come up with a different solution, and almost gets to the point where you have to show that they would have. And I think in this case, despite the dissent, we've met that burden because these texts were specifically, the jury was specifically told they could use these texts, which were highly prejudicial. Someone said these texts were slut shaming her. They were showing that she was a bad woman, a bad mother, presumably a bad wife. And the jury was instructed they could use that. So I think Reber has been met as opposed to what the dissent found. But going back, if this court does decide to review 403, to me it's irrelevant. It's Rule 401 that was violated because the court made no relevancy decisions. And in the first Court of Appeals opinion, they very politely suggest when this case gets remanded, the trial judge should review for relevancy and then 403. So first we have to get beyond 401, and 401 is not discretionary, it's de novo. So we can't get beyond that. There was no relevancy at all at the trial court decision. Also, and as far as 403 is concerned, in this case, it's risen to the level of denying the defendant her due process rights to a fair trial. It's a constitutional issue, and I've sent up a memorandum of additional authority listing several of the cases which this court and the Court of Appeals have reviewed constitutional error.
I wonder if that's not problematic for you, though, because to the extent we're looking at due process concerns and the fairness and the integrity of the proceedings, notwithstanding the denial of the PDR uninvited error, looking at the totality of the fairness of the proceedings, it seems like that brings back in the invited error. You raising this due process brings back the invited error because this was an exhibit that defense counsel used aggressively in cross-examination. So do you see where I'm feeling some tension there?
Even if the defense attorney wanted to use certain segments of it, it still could have been redacted. I mean, I can't imagine any scenario where the defense attorney wouldn't have asked to redact some of those explicit pictures, redact the stuff that is totally irrelevant, talking to her son about his health exam, talking to her son about calling a law enforcement agent a dick. All that could have been redacted. So yes, it's ineffective assistance that he didn't even ask to redact it. I'm not sure if this court is aware. I'm sorry.
No, go ahead. I'm sorry. I apologize.
But the trial attorney, Frank Wells, died unexpectedly a couple of months after this trial. And this court has been notified of that because he had cases up here that had to be reassigned. So the MAR path, going back for ineffective assistance, really isn't available to Ms. Hicks because the attorney can't be questioned, obviously.
But with your argument, essentially what you're asking us to do, or at least it sounds like to me, is sit back here and think, well, why didn't the defendant or defense counsel object to the introduction of this material? And there are one of two ways that we can go with that. One would seem to be to go, well, that at least sounds like trial strategy. And based on some of the arguments that were made, looks sort of in line with trial strategy. And that would be one way, and that gets you to an ineffective assistance claim. Maybe it was appropriate or not. The other seems to be that you're asking us to presume that defense counsel was incompetent. And I'm just not comfortable with that. You're asking us to step in and say, defense counsel clearly missed this and made a fundamental error and lacked the competence to know when to object. Why is that? Is that the choice, and why is that the wrong way to
That would go to invited error, which is this court explicitly said we were not going to reach today. But if a strategy, my presumption, and this is a guess, which I'm not allowed to do, is that Frank Wells thought his case of self-defense was so strong that no jury was going to find that when a man forcefully breaks into the house shouting, "I'm going to kill you," would not find self-defense. He clearly underestimated the revulsion the jury would feel by looking at these pictures, by reading the text with friends about how many people they'd had sex with. For some reason, he misjudged the weight of that, but I think it was because he was so confident that no jury could not find self-defense, that maybe he wasn't being as careful as he would have been if the Castle Doctrine didn't so clearly apply in this case, and so clearly Ms. Hicks was not guilty of murder because she was protected by the Castle Doctrine. I don't know if that answers your question.
No, in part, I have concerns with when not just you, when attorneys are arguing plain error, they are essentially asking us not to go first to, oh, that could have been trial strategy. And so I'm not saying that there aren't situations where plain error is available, but that bar is so high on plain error that ineffective assistance of counsel seems more conducive to the relief that you're asking for, generally.
It would have been if Mr. Wells had not passed away without providing any information about what he was thinking. So we can't go back there. And we were never at a point in this appeal, because the appeal was docketed after his death, when IAC was conceivable. But I would like to go back to why Mr. Wells must have believed he had a right, because as this court has found, 135 has a presumption that if someone breaks into your house forcefully, in this case, after being told not to come, the person who uses defensive force knew or had reason to believe that the unlawful and forcible entry was occurring or had occurred. That's all presumptive. And how the jury could find or that she was the aggressor when she told him twice not to come in, when he came in shouting, "I'm going to kill you." There's clearly not only a presumption that she was in danger and her daughter was in danger. He said it. He said, "I'm going to kill you." Then he goes in, grabs her gun, and points it at her. So Mr. Wells, and I believe most of the population, would think this is the Castle Doctrine. This is self-defense. So we have to question why this jury went off the rails. And the only answer is the combination of the instruction on the aggressor doctrine that they could use prior writings as provocations to find an exception to the Castle Doctrine, with the fact that this jury must have thought she was just a slut. She's having sex with multiple men. She's getting drugs for the victim by having sex with his drug dealer. She's telling her son to lie to the school, to not cooperate with law enforcement. A Randolph County jury who has been instructed that they could use prior writings to decide whether or not this was a case of self-defense is going to use it. And that's where the plain error analysis has to be, not with some random jury, but with this jury. So what this court has to look at is when this jury was instructed incorrectly, as this court has since found in State v. Phillips, when it was instructed incorrectly that they could use these writings, and then they followed that direction, wasn't that prejudicial? And going back to the plain error standard, my colleague only limited it to whether or not it was a bad reflection on the judicial system. But there's also the question of whether or not it was fundamentally unfair. And under Anders v. White, it was fundamentally unfair for the jury to be given this pretty fat number of pages, 99.9%, which were irrelevant, and the remaining disgusting, absolutely disgusting. And not only does the state point out to the jurors once, they bring up these pictures 3 times. And I hope you didn't have to spend too much time looking at those pictures, but they're disgusting. And they would have disgusted a Randolph County jury. And in this case, they convicted her not based on whether or not she had a right to self-defense, but because she was a bad woman. Justice Alito and Andrew v. White concurred because our case law establishes that a defendant's due process rights can be violated when properly admitted evidence at trial is overwhelmed by a flood of irrelevant and highly prejudicial evidence that renders the trial fundamentally unfair. And that's one of the plain error standards. Is this fundamentally unfair? And it was fundamentally unfair to cast Wendy Hicks as a bad person. When, in fact, whether you agree or disagree with her lifestyle, she was a working woman. She was getting up to go manage the HVAC at a factory, and that's where she had met Caleb when he was fired for having sex with various women in one of the warehouses. So this was part of her life, but part of her life was being a hardworking woman supporting her children. So it was fundamentally unfair. And we raised this as a constitutional error back at the Court of Appeals when I first filed a brief, that it was a constitutional error, not just 403B, but 403B as a constitutional error. So if this court has any questions? Thank you.
Thank you, counsel.
I ask you to find Wendy had a right to castle defense and that it was this prejudicial evidence that threw the jury off the rails and caused them to convict her. Thank you.
Thank you, counsel. Rebuttal.
Yes, Your Honor, just be fairly brief. Just I want to touch on a couple of the matters that were raised there. One is this thread that appears, it actually arose in Justice Morgan's dissent in Hicks 2. It appears again in Hicks 3 from the Court of Appeals. This idea that Wendy was protecting her daughter, and that's why the jury could have, it's part of what the state notes, is that evidentially a big problem is the fact that Caleb was shot in the back twice. That tends to undercut, fairly obviously, a defensive force claim. And the argument is that, well, she might have been protecting her daughter. Wendy Hicks testified, and that is, this idea of protecting her daughter is just made up out of whole cloth. That appears nowhere in the transcript. The daughter never says she needed any protection. The Wendy Hicks never says she was protecting her daughter. That is completely something that is pure speculation. Whatever amounts to plain error, surely speculation as to can't be it. Regarding this aggressor doctrine idea, two points on this. One is, even under the statutory rubric, the aggressor exception is not a rebuttal of the presumption of reasonable fear under the Defensive Home Statute. It is a not available. It doesn't apply. It is not about a rebuttal. So the idea that the jury found her to be the aggressor means the defensive habitation statute doesn't apply, not that whether or not it rebuts the presumption of reasonable fear, which Phillips limits to only those 5. So the Phillips issue really isn't before this quarter, is sort of a sideshow to that. Relatedly, though, I do want to touch on Justice Dietz's comment, I believe it was your dissent, in Hicks 2, about this idea of a common law aggressor doctrine versus the aggressor as it is codified in the statute. The statute talks about this initially provoking language, whereas the common law aggressor doctrine seems on its face to be a little broader, with this idea of continuing the fight in particular, which is where shooting somebody in the back who has since instigated a fight with you, and they go to walk away, and then you continue it by shooting them, that would be very much an aggressor under a common law standpoint. The question of whether the statute is coextensive with that definition of aggressor. One point is, as you observed in the concurrence, I think it was, is that issue wasn't before the court in Hicks 2. It hadn't been briefed at all. It's certainly not here now. Just if I was going to make an observation on it, I would note that to the extent, if we are going to hold that, if we're going to construe this initially provokes narrowly so that we don't encompass the common law understanding of what that means, it's very difficult to apply this aggressor statute, because it's specifically not available to someone who uses defensive force with respect to habitation. And it's very difficult when you read that statute to think about how an initial provocation, if we confine that limitedly, in a limited sense, rather than the common law idea, could even ever occur. So that kind of construction sort of is a little bit at odds with the language of the statute. But again, it's not really before this court. Anyway, text showing that she was a bad woman, bad mother, and so on. These texts were not flattering to anybody. These texts made both of these people look really insufferable. And that is one of the things that was so useful in this material to defense counsel, was how bad these texts made Caleb look. The issue is not Rule 403, it's Rule 401. The Court of Appeals has expressed that it's a 403 error that they are finding, and the dissent is expressed on that point as well. It is not, even if it's Rule 403, it's a due process violation. I think that's problematic for the reasons that Justice Riggs mentioned. I also think that brings up the idea that a due process violation is not a plain error issue. That is a federal habeas issue. That relates to the Andrew v. White case. Whether evidence was admitted in violation of due process or something like that, White itself, the Andrew case itself, is a habeas case. That is a habeas question. That does not create an exception or modify state plain error law with respect to state evidentiary claims and state preservation claims. This idea that we can't do an MAR because the attorney in this case has unfortunately passed away. That would certainly be a significant evidentiary hurdle, but it still ends up begging the question of whether or not there is, I mean, on the face of this, there is a legitimate trial strategy effort in using this material. This presumption of reasonable fear versus presumptive right to kill, I think that's a problem for the reasons we articulate in our response to the MAR and the Williams brief that came in as attached to that. The last one I had was the Andrews case as fundamentally unfairness as a constitutional issue. In closing, the state thinks there's no basis for the Court of Appeals to find plain error here on any grounds for plain error, nor does the state thinks Phillips or the MAR provides any other basis for the defendant's request for relief.
Thank you, counsel. Clerk.
Thank you, Your Honors.
All rise.